Well, hi everyone. Welcome to our webinar on ensuring your charity is legally compliant. My name is Jessica or Jess, and my co-host is Ushna. So before we begin, just a couple of housekeeping items. So you'll receive a copy of the recording and the slides in your email after the webinar. You can submit your questions in the chat box during the webinar and we'll answer them at the end. And thanks for the couple of questions that we've already received. And after the webinar, there'll be a very quick survey for you to complete. We always appreciate your feedback. Okay, so you are eligible for a free consultation with LegalVision for the next 48 hours. So all you need to do is provide your contact details in the survey at the end of the webinar. Okay, so today we'll be discussing a number of things. We'll try to cover a lot and get into a bit of detail where we can. So firstly, setting up your charity correctly. We'll look at governance and reporting requirements. We'll look at fundraising compliance. We'll chat about things to think about when you're engaging volunteers and employees. We'll have a look at some of the privacy considerations for charities. We'll have a think about the Australian consumer law and marketing concerns, and then we'll have the Q&A at the end. So Ush and I are quite passionate about charities, and we see that it's often a confusing space, and understanding your obligations as a charity, or if you're interested in becoming a charity, is quite overwhelming. Charities are held to a really high standard, but many people are not actually aware of how to meet those standards. So we want to clear that up a bit today. And we also see the fact that lots of people involved in charities are volunteers, and they might not necessarily understand the laws and requirements involved in running a charity. So I'm going to hand over to Ushna, who's going to speak about ensuring your charity is set up correctly.
Thanks, Jess, and thanks for such a wonderful introduction. So the first and perhaps the most essential aspect of being a legally compliant charity is ensuring that your charity is set up correctly, as Jess mentioned, in order to be registered with the ACNC. The primary element that best ensures your structure is correct and stays correct is your charitable purpose. So a charitable purpose is, of course, the reason that a charity's been set up and what its activities work towards achieving. There's got to be a clear match between what your charity is aiming to do and what it actually does. Charitable subtypes reflect your charitable purpose. The ACNC Act sets out 14 charity subtypes. To be eligible with registration for a specific subtype, your organization's objects and activities must be directed towards achieving the charitable purpose described by that particular subtype. To ensure that your charity is legally compliant, you should only choose subtypes that represent your organization's current purposes. So that means that you really shouldn't apply for subtypes that may reflect a future purpose of your organization, or something that you're working towards, or something that was relevant when you first started long ago. Jess is now going to touch on some other key aspects of your charity setup, starting with governance and reporting.
Thanks. So this is a bit of a, I suppose, meatier part of charity compliance, and that's your governance responsibility. So we'll try and get into a little bit of detail here. If you have questions, we can touch on them at the end, or we'd love to have a more detailed conversation with you afterwards if necessary. So yes, you will have a number of corporate governance considerations as a charity. And if you have an incorporated structure, many of you who are familiar with this business world would be familiar with many of the Corporations Act responsibilities. But if you become a registered charity, certain parts of the Corporations Act responsibilities are actually switched off. So that's things like many of the directors' duties and financial reporting and auditing obligations. But of course, they're not switched off without something sitting in their place. So what's in place of these provisions of the Corporations Act? So it's the ACNC governance standards, and I'm sure most of you are familiar, but when we say ACNC, we're talking about the regulatory authority for charities and NFPs in Australia, the Australian Charities and Not-for-Profits Commission. So we've got these 6 ACNC governance standards. So I'm going to run through these. So standard number 1, this is about your purposes and your not-for-profit nature. So your charity needs to operate as an NFP, and it needs to work towards this charitable purpose that Ushna mentioned, and you need to be able to demonstrate this in your governing document and on your accounts, and be able to provide information about your purpose and your NFP nature in communications that you have with the public. And this is really an ongoing obligation. It's not just something you need to set up at the start. It needs to continue throughout the lifetime of your charity. The second standard is accountability to members. So this is really about giving your members an opportunity to raise any concerns that they might have about how the charity is governed. You need to be on an ongoing basis communicating with your members and letting them know what's going on with the charity. So this is things like on regular meetings and email updates and that sort of thing. Perhaps an obvious one, it is compliance with Australian laws. So your charity needs to be not involved in or responsible for serious offences, so things like fraud or criminal activity. And I'll touch a bit more on that later. Number 4 is the suitability of responsible people. So people like the directors and committee members. So you need to make sure that these responsible people aren't disqualified from managing a corporation, either under the Corporations Act, or you need to make sure that the ACNC hasn't disqualified those responsible people. And then if someone becomes unsuitable, you should remove them as a responsible person. Number 5, about the duties of the responsible people. So you need to take reasonable steps to make sure that the responsible people carry out their duties, which are quite similar to directors' duties actually, with reasonable care and diligence. They need to act honestly, they need to not misuse their position, they need to disclose any potential conflicts of interest as they arise, and they need to make sure that financial affairs of the charity are managed responsibly and not allow the charity to operate while insolvent. So I'm sure many of you are sort of noting the similarities between the director's duties. And the ACNC website itself actually has some very good information on these duties, and we recommend that responsible people familiarise themselves with these duties. And then number 6 is about maintaining and enhancing public trust and confidence in the Australian not-for-profit sector. So not-for-profits and charities are held to a really high standard, and we need to be making sure that all charities are really promoting the fact that charities can exist and are well respected in Australia. So more specifically, this looks like you need to take steps to become a participating non-government institute of the National Redress Scheme. And this ensures that the charity is responsible for any past misconduct relating to child abuse. So if there are any concerns about that, any concerns about past or potential misconduct relating to child abuse, definitely seek advice and we can give you some guidance on that. I'll touch on financial reporting now. There are many obligations depending on what state you're based in, but I think many of you would have heard that there is good news. It sounds like there are moves towards a national fundraising scheme or regime, which could hopefully consolidate the state-by-state laws. And financial reporting is another ongoing obligation that you have. It's not something that you sort of just do once. So what does that look like? So that looks like submitting an annual information statement to the ACNC, and this helps the ACNC sort of understand the charities that are within the Australian charities sector and reduce the reporting burden for charities. Now, if you're a medium and large charity, you must also submit annual financial reports that are reviewed or audited. So what's a medium or large charity? Well, it's really determined by the size of the annual revenue. So if you're over $500,000 of annual revenue, you're going to be at least a medium-sized charity. So it's important to familiarise yourself with your financial reporting obligations. Okay, a couple more points from me before I hand back to Ush. I know it's nice to mix it up a little bit. So just speaking about some practical obligations around keeping true and accurate records. So when you are running fundraising campaigns, if you're running multiple campaigns either at the same time or one after the other, it's important to make sure that you're really clearly identifying the records of the individual campaign and making sure it's clear where the funds are going and to which campaign those funds relate. And certainly keep funds raised separate and safeguarded from other personal or organisational funds. You should check whether there are any extra reporting requirements above and beyond the general requirements set out in the fundraising regimes. And then just also remember that in some jurisdictions, fundraisers need to notify regulators if certain things change about the fundraising activity, such as the key contact people or the registered address of the fundraiser. And so, yeah, lots of state-by-state regulations, which we appreciate is complicated and a bit overwhelming. Does sound like there are moves towards a national fundraising regime, and also moves towards a national consistent rule on what is a charity. There may also be a central set of governance duties for committee members, and we may also be seeing a bespoke kind of legal entity or legal vehicle that's specifically designed for Australian charities, and this we'll see, but it might be called an Australian Charitable Incorporated Organisation. So that was a lot of sort of meaty content. I'm going to hand to Ushna, who's going to speak about fundraising compliance. Just on mute, Ushna. Classic.
It's got to happen once during a presentation. So I was just saying, we're moving on now to one of the main aspects of charities, which is, of course, fundraising. This is also the area that attracts significant compliance requirements, so we've got to be really careful. Each state and territory also has different requirements around who can carry out fundraising and what the requirements are. So let's do a really high level summary of each of the states. And, if you're in a specific state and you want more in-depth advice about your requirements, we'd definitely love to have a chat with you on a consultation after. So starting off with New South Wales, which is where we are. So in New South Wales, what you've got to do is obtain an authority to fundraise, and that's valid for a maximum of 5 years. In Victoria, you have to register as a fundraiser unless the organisation is already a registered charity with the ACNC, and an organisation or an individual must apply for registration at least 28 days before conducting any fundraising appeal, and the registration period for that is 3 years. In South Australia, you've got to obtain a collections for charitable purposes licence, also known as a Section 6 licence. So a charity registered with the ACNC is deemed to hold a Section 6 licence if it notifies the consumer and business services of its intention to fundraise in South Australia. In Queensland, you have to register as a charity through the Office of Fair Trading or obtain an authority from an organisation already registered as a charity in Queensland to fundraise on behalf of that charity. Or you can also obtain a sanction through the Office of Fair Trading for a particular appeal or for a community purpose. In Tasmania, charities can be registered with Consumer Building and Occupational Services, who actually maintain a public register of charities that are registered to collect charitable donations in Tasmania. So any incorporated associations that are registered in Tasmania and companies which have a principal office in Tasmania don't need a separate registration to collect as a charity and are not included in this list. Approval to fundraise in Tasmania may be required for incorporated organisations that are located outside of Tasmania, or companies with a principal office located outside of Tasmania, or non-incorporated groups or associations, and individuals as well, unless they're kind of carrying out that fundraising on behalf of an organisation that's already received that approval or that's already been exempt from the requirement for an approval. So Tasmania is a little bit of a tricky one. In Western Australia, you've got to obtain a charitable collections license through the Commissioner for Consumer Protection. And finally, in the ACT, you've also got to similarly obtain a charitable collections license, and that's valid for up to 5 years. So noting that, you know, each of these states have kind of different validity periods for these licenses. So really make sure that you check up on that depending on the state that you're in. It's also important to note that even if approval is not required, you will still need to generally comply with the obligations in your specific state. And so generally these obligations are that, you know, you should ensure that your fundraising activities align with the purposes of the charity. You should make sure that any money that you've raised is given to the intended beneficiaries or used for the purposes for which it's actually obtained. It's really important. You should make sure that you've got high standards of governance, which Jess has just touched on, and also that you've got risk management that's applied to any campaign that you might run. And finally, you've got to meet specific requirements if you're involving any children in those fundraising aspects. So that at a high level is kind of the requirements in each of the states. But like I mentioned earlier, we'd be more than happy to go, you know, more in detail with you specifically if you reach out. And now I'll pass back to Jess, and Jess is going to start talking through kind of some of those obligations for volunteers and employees.
Thanks. Just checking I'm off mute, yes? Okay, so we get lots of questions at LegalVision, both from charities and non-charities alike, about engaging employees and volunteers, and we know that volunteers are really common in the charity space, so we think it's important to understand those obligations, and so we'll run through a couple of those now. So really, I mean, at a high level, you should be ensuring that your workers, so whether employees or independent contractors or volunteers, are all classified correctly as such. And that's not just a matter of giving them a sort of a badge that says what they are. It's really considering how you're engaging them and considering any sham contracting risks to ensure that if someone is actually, you know, you can't just call someone a contractor when they may in fact be an employee and deserve and are entitled to the rights as an employee in Australia. So a question we receive a lot actually is, are volunteer arrangements lawful? Yes, they are. They are certainly lawful. There are just some things we need to think about. So we see volunteer arrangements a lot, particularly for vocational placement. So that's often students getting work experience. But again, we just want to make sure that there's no employment relationship there. So some of the key characteristics of an actual volunteering or a genuine volunteering arrangement include the fact that the parties, so that's probably overly complicated, but the charity and the volunteer didn't intend to create a legally binding employment relationship. And then another key aspect is that the volunteer is under no obligation to attend the workplace or the sort of location where the charity is fundraising or performing its work, and that the volunteer is under no obligation to perform work. It really has to be voluntary. And then, of course, another component is that the volunteer doesn't expect to be paid for their work. If there is a bit of confusion there, certainly worth seeking some advice and making it very clear that it is indeed a volunteer arrangement. So if there is an employment relationship, what are employees entitled to? So they're entitled to a minimum wage. They're also entitled to the national employment standards, so things like maximum weekly hours, leave, annual leave, long service leave, sick leave, and requests for flexible working arrangements. And you'll also need to comply with any applicable modern award or enterprise agreement, including by making sure that the leave entitlements and that the wages comply with these modern awards or enterprise agreements. And then once you've sort of received advice and figured out how all of your workers are engaged, it's obviously really important to have an agreement in place for those. So whether that's an employment agreement or a contractor agreement or a volunteer agreement. You do also have ongoing compliance obligations under the, for record keeping under the Fair Work Act and the Fair Work regulations. And then you'll also need to have policies that you continually update and provide training on things like anti-bullying, discrimination and harassment, work health and safety, and information technology. So again, these are all not things that you just need to set up at the beginning of establishing a charity, but also on an ongoing basis. Okay, so now another really common and frequent question we get is about privacy obligations for charities. So Ushna is going to speak about that.
Thanks, Jess. So yeah, look, as a charity, you deal with a lot of personal information and perhaps even sensitive information. So donors really trust you to handle all that information appropriately. And it's really important that you comply with your privacy obligations when dealing with that information. So the main framework for privacy compliance in Australia is the Privacy Act, which sets out 13 Australian privacy principles, or APPs as we like to call them. These principles are relevant for all organisations, including not-for-profits, to know how to handle the personal information that you might receive. So your not-for-profit should have a clear and easily accessible privacy policy that outlines, how you collect, store, use, and disclose personal information that you receive. It should also inform donors about their rights regarding their data. For example, rights to be able to access, correct, or request for removal of the information that you hold. And wherever possible, you should allow the options for people to interact with your organisation anonymously. What this does is that it encourages trust and it ensures that donors have some sort of control over the personal information that they're providing you with. Another really important step to take is to ensure that any personal information that you're collecting is reasonably necessary for your functions or your activities as an NFP. You should be quite clear about why you need the information, and you should ensure that any of the information that you are collecting is by fair and lawful means. So, practically what that means is that you should inform donors of the purpose of the collection of that personal information. You should inform them who you might disclose it to, and any relevant consequences if they choose not to provide it. And really, you should only be disclosing or using that personal information for the primary purpose of collection or for a secondary purpose that directly relates, unless an exception applies. So an example might be, the primary purpose is the purpose to provide our services to you, and a secondary purpose might be, say, a marketing provider that you need to have access to in order to provide those services. So you should really obtain consent if necessary, and consider any reasonable expectations that the donor might have as well. Another really important thing that's often overlooked is thinking about where you store that personal information. So if you're storing that personal information overseas, you really have to make sure that you're taking reasonable steps to ensure that the recipient of any of that information complies with those Australian privacy laws. This is definitely going to be consideration for, or not definitely, but often it's a consideration for any cloud storage that you might use. And you want to disclose to those donors where you will be storing that personal information overseas, just to make sure they have no objections to it. So, I guess at a very high level, those privacy obligations apply across the board to organisations in Australia, whether you're a charity or not. And this is quite similar also with your ACO obligations, which I'll pass back to Jess to touch on now.
Thanks. Yeah, definitely related to your privacy obligations is your consumer law obligations and your marketing obligations. So it's really important to make sure that your fundraising campaigns are truthful and that you don't make any misrepresentations, and that you also comply with any requirements for adding your license or your registration number to any advertising materials, any packaging that you might have, or otherwise any communications like emails. So it's a really common strategy to promote campaigns on social media. We're seeing that done a lot these days. However, it's important to remember that you are responsible for comments and posts on your social media platforms, including those that are likely to be false or are likely to mislead. So some practical steps to reduce the risk there, or reduce the potential of this happening, is to have a really good set of community guidelines and clearly display those on your website and on your social media platforms. You should only, another strategy is to only allow comments and posts to be created once you've reviewed them and approved them. You should be regularly reviewing and responding to or removing any posts, including reviews, that are potentially false or misleading. And then you should certainly block any user who breaks your community guidelines. And so I mentioned just before, it's important to not make any false representations about your charity or about your purpose or about your campaigns. So we've seen this done by charities making representations that another organisation endorses, or maybe even a public figure endorses your charity, by including that organisation's logo or trademarks in advertising in circumstances where that organisation hasn't given that approval or hasn't endorsed your charity. And so another common example of this is where charities sort of represent that a notable person or a celebrity is a patron of the charity or of the campaign, when this is not the case. Again, this is going to mislead the public and mislead potential donors. And then, of course, it might also create friction with that public figure, with that person. So really best to avoid doing that. And where you do have a formal arrangement where you're endorsed by a particular person or a patron or an organisation, have a formal agreement in place with them. It doesn't need to be complicated, but it just needs to set out the instances where you can use their name, their branding and things like that, and for what purposes. And then we also just want to touch on what you need to think about when sending electronic messages like marketing emails or texts. So many of you would be aware of the Spam Act, which prohibits the sending of spam. So registered charities are exempt from certain parts of the Spam Act, but our sort of guidance here is that it's still unwise to create friction with your marketing list. And so following the Spam Act laws and requirements is probably best practice there. So that's things like making sure you clearly identify your charity name and sort of registration numbers in all of your materials, in all your marketing materials and your emails. And then making sure you have a functional unsubscribe. So an easy way for people to opt out of the text or of the emails if people no longer want to receive those marketing communications. And if an electronic communication, like an email or a text, doesn't include any marketing content, it's purely factual, this is sort of not an electronic communication for the purposes of the Spam Act, so you won't need to comply with those requirements anyway. Okay, so that is sort of bringing us to the end of the bulk of the webinar, which is great, and we're really happy to see your questions flying in, which is wonderful. So please feel free to continue submitting those. We have a publication that you might find useful. You can whip out your phone and access that via the QR code for a free download. We also want to let you know about our upcoming event. So this is our last webinar of the year, which is quite exciting, but we do, of course, have another one early next year on the 6th of February. So it's called Venture Debt, Is It the Solution for Your Startup? May certainly be interesting to many of you, and you can register for that now. That's another free webinar. Questions are still coming in, which is great. And I'll just quickly touch on LegalVision membership in case you haven't heard of it. So by becoming a LegalVision member, your business gets, or your charity, I should say, gets unlimited access to our full team of 100 plus specialist lawyers, including Ushna and myself. We all work in the same team here for all of your business as usual legal needs. So we think of it as like having your own in-house counsel for a fraction of the cost. And our team can assist with unlimited document drafting and reviewing business contracts. We can assist with unlimited legal advice consultations, and we can do unlimited domestic trademark registration. And then we also offer a membership for in-house teams and general counsel, so that can help to manage your high-volume business as usual legal tasks. And so we've touched on this a little bit today, but practical ways we can assist with your charity is we can give advice and help set up and incorporate your NFP and help to register your charity and obtain that DGR status if that is something you're interested in. We can advise on your ongoing corporate governance and compliance obligations. We can advise on obtaining charitable fundraising licenses in all the states and territories. A big part of what we do is drafting commercial contracts. So preparing authorities to fundraise is common. And then, as I mentioned before, certainly when you have partnerships with individuals or organisations who are endorsing your charity, you can draft those agreements or review those agreements. We can give advice on privacy and draft your privacy policy, and we can also give advice on everything employment and HR, including drafting your employee, independent contractor and volunteer agreements. So to learn more about how membership can help you, all you need to do is request a free consultation when the survey appears at the end of the webinar. Okay, so we're going to get stuck into your questions, which is great. So there was one pre-submitted, so I'll touch on that first. So this is an interesting one. So it says, there has been a lot of political noise about charities speaking publicly about policy or politics and then stripping of charitable status. Are there any legal risks in doing so? Are there any legal risks in speaking publicly about policy or politics? Yeah, certainly a controversial topic. And I suppose it's interesting because advocacy and representation of issues is a really key part of charitable purposes. But under the Charities Act, there are also disqualifying purposes. So disqualifying purposes are if you engage in or promote activities that are unlawful, or if they're contrary to public policy, or they promote or oppose a specific political party or candidate. So if you are engaged in a disqualifying purpose, you could be deregistered from the ACNC. And then when the ACNC revokes charity status, it removes an organisation's entitlement to access tax concessions. So that is obviously not ideal. So specifically regarding the support of or opposition of, I should say, of a particular candidate, it is okay provided a few things are met. So, provided you're making submissions relating to any existing or proposed laws or government policies. It's okay provided you're developing or publishing research on current or proposed laws. Certainly generally okay if it directly relates to promoting your purpose or the interests of your beneficiaries in the context of promoting your purpose to elected representatives or public officials. And then it's also okay if you're hosting or promoting debates on laws or policy. Where we've seen it's not okay is where you're delivering how to vote cards on a particular candidate, where you're donating money to a particular candidate or a particular political party's campaign, and then also where you're attending fundraising events for a particular party or candidate. And so we're sort of getting back to ACNC Governance Standard 3, which changed in 2021 to include that point about restrictions on acting in a way that under law could be dealt with as a serious or indictable offence. It was sort of, we initially saw concerns about whether that was, whether attending events or gatherings was at risk of contravening this governance standard. But the ACNC makes it pretty clear that in order to determine the purpose of the charity, the ACNC is going to look at the charity's governing documents and its ongoing activity, and it's likely that a sort of one-off activity is unlikely to demonstrate that a purpose of promoting, a one-off activity is not likely to sort of make you fall foul of this governance standard. And the sort of useful resource that you might find interesting is the ACNC's, it's a guide, it's called Political Campaigning and Advocacy by Registered Charities, What You Need to Know. And so that's a really useful guide we'd recommend reading. So yeah, long question, long answer. There are definitely risks in undertaking really sort of volatile advocacy, but the purpose of the governance standards are not to give charities a platform to promote anything violent. Really, a sort of a really thoughtful and balanced advocacy is unlikely to get you in trouble with the ACNC. So I hope that helps. Ush, did you want to take another question?
Yep. So we've had a few questions come in, which is great. Maybe I'll just start off with one that's, I guess, pretty important, which is, what the difference is between an NFP and a charity. And we've also had another question about what the difference is between an NFP and a social enterprise. So I'll try to answer those all in one. Completely appreciate how confusing this can be, and oftentimes the words are used quite interchangeably. However, they are very different. So in a nutshell, all charities are NFPs, but not all NFPs are charities. So a charity is really just a type of NFP. We know what an NFP is. It's an organization that operates, not to make profit. And the key difference is that a not-for-profit doesn't have to reach a charitable status, whereas a charity is an NFP that's had to reach that status by meeting, quite specific and strict guidelines, which you've spoken about today. For example, having a charitable purpose for the public benefit, not being a government entity or having a disqualifying purpose, all of those things. And a fun fact is that, there's over 600,000 NFPs in Australia, and only around 60,000 or so of them are actually charities. So that's really important. And then you've got social enterprises which are thrown into the mix. And the key difference really between a social enterprise and a charity and an NFP is a social enterprise is more of a term that's used quite colloquially. It's not defined under the law. It's really just an organization that is designed to achieve a particular social outcome. So some examples of these might be, the thank you or who gives a crap. So these are organizations that look like NFPs, and they might, from the outside operate as NFPs. However, they're really operating for profit. There could be instances where they're actually giving those profits to, charities overseas or in Australia. However, as an organization, they're not operating as an NFP or a charity. So there is that clear distinction between the three of those, but completely appreciate how it is used quite interchangeably, and it can definitely become quite confusing. And while I've got you, maybe I'll just answer another question as well that's come through, which is also a quick one, which is in New South Wales, who do we actually obtain an authority to fundraise from? And this is specifically for an ACNC registered charity. So the important thing is that if you're an ACNC registered organisation, you are automatically eligible to receive an authority, but you've still got to complete and submit an application. And that application is actually on the Service New South Wales website. So if you type into Google, apply for fundraising license, ACNC charity, you should get through to the link, and you've basically got to fill out a form online and submit that in order to be able to receive that authority. So that's specifically for New South Wales, but like I said earlier, definitely can have a chat about the other states. I'll pass it back to you now, Jess.
Thanks. Okay, so another question here is, does the fact a director has an ASIC director's ID indicate that they haven't been disqualified, or are we required to do further checking? So the simple answer is that you can do a search on the banned and disqualified register through ASIC, which is free of charge to access. But at the moment, a person's ID is not connected to specific directorships yet. I think we'll see in 2024 and 2025 a merge with the Australian Business Register. I think that will happen then. So yeah, we'll see what happens. Okay, we'll try and get through a few more. Conscious that we're sort of running out of time, but we'll keep going. Okay, so another question is, does that mean a consultant or a contractor needs to have an ABN as a mandatory requirement before we engage them for work? And what if we are engaging a contractor or a consultant outside Australia? The organisation is based in Vic. So yeah, good idea to, if you are engaging a consultant or a contractor, to make sure that they have an ABN. If you are indeed engaging them as an independent contractor, they might also be sort of registered for GST purposes and other things. So it's important that if they are indeed a sole trader or a company, that you put that documentation and that sort of ABN on your contracts with them. And not a problem if you're engaging a consultant outside Australia. That happens very commonly. Ideally, you'd have that contract drafted under Australian law so that the contract is interpreted under Australian law, and so that if there are any disputes, they're dealt with in Australia. There's certainly other laws in other countries that are on a similar level to Australian laws, but we know certainly at LegalVision and Australian law firms know how those contracts will be interpreted. We know how disputes will be dealt with here in Australia, so best to have that all governed by Australia. Okay. Let me just see what else I can answer while I've got you. So there's a question here, what are our obligations to make volunteers aware of our WHS and other policies? Here I'm mainly referring to short-term volunteers who only work for 1 to 2 day events. Yeah, that's a really good question. So I think even at the start of when a volunteer is going to be helping you out for a day or two, good to have them just read through and sign a simple volunteer agreement. It doesn't need to be a really extensive thing, but it's just going to set up what their obligations are and what your sort of key policies are. So if they're attending a premises, how can they be safe? And if they're dealing with IT and social media, what sort of rules do they need to comply with when dealing with those things? So really good to just make them sign something simple at the start of that short engagement, even if it is only a day or two. Okay, Ush, I might hand back to you to answer a couple.
Yeah. And I guess just before I continue, we are going to extend the webinar time just by a little bit because we've had so many questions come through, and we're going to try to get through as many as we can. But if we don't get to you, like we mentioned a few times, we can definitely have a consultation with you to answer those specifically. A question that was asked that kind of off the back of the previous one that I answered was whether LegalVision can assist with NFPs that are not charities. So the short answer is yes, and the long answer is there's a range of things that we can assist with in the space. So some examples are we can assist you with your initial setup as an NFP. We can then assist you with that ongoing corporate governance and compliance, and we can draft any commercial contracts that you might need. Including things like also policies like privacy policies, privacy collection notice, employment agreements, and then there are specific charity things that charity kind of legal assistance we can do for you, like registering as a charity, any advice in your specific state. Some of the things that we don't assist with normally is setting up charitable trusts or private ancillary funds or public ancillary funds. But look, we can definitely have a chat with you on a case-by-case basis to see what we can assist with. So definitely reach out. And another really good question is, I guess, what the consequences are practically for non-compliance. So there there's a range of things that you've got to think about as a charity or as an NFP. There are definitely consequences for compliance. There's a few different things. So I think Jess did mention previously, that disqualification or that revocation of your charity registration. So that's probably a key one. Practically what that would mean is that you would lose access to any government funding you've been receiving, any exemptions, concessions, benefits. So that's one. But I guess before that stage, you might be issued warnings or directions from the commissioner out of their enforcement powers. From a financial perspective, there's definitely penalties that can be issued, and they're actually all outlined on the ACNC website. So I'd encourage you to go have a read of that. But some of the things that they might penalize you for example, if you're making any false or misleading statements about your charity or your NFP, and also if you fail to lodge documents on time. So that's a really important one. And I was having a bit of a browse on the Victorian website, and there's actually differing amounts depending on the time period by which you're delayed in submitting those documents. So yeah, definitely a few different consequences depending on the severity of your non-compliance. There was a question about whether or not this varies for a small charity or a large charity. I have not at this stage been able to find any distinction online. However, definitely keep posted, and that's definitely something we can look into more for you and have a further chat about. But at this stage, it really just seems to be kind of a blanket penalty for that non-compliance. Jess, I might pass back to you.
Yeah, thanks. So I think this will be our last question, and I'll touch on this really briefly, but this is something we'd love to speak to you about in more detail. I think a chat with our employment team would be really beneficial here. And so the question was, what are the requirements if we have casual staff who have worked regular hours for over 6 months? Do we need to offer permanent part-time roles, or are we only obligated if the employee requests to be permanent? Yeah, that's a really good question, and as I said, certainly something it's worth seeking guidance on. So yeah, if there's sort of real regular hours and an expectation of ongoing work, and it's falling more into that sort of more permanent position, it's a good idea to reassess whether they are sort of a permanent position, reassess whether you need to reconsider the employment contract you've got with them and the wages and things like that. So it won't just be if the employee requests, it'll really be worth seeking advice on that. So we'd love to chat to you about that further. So I think we'll leave it there. I think we got to most of the questions, but if there are any that we didn't get to, or certainly for that employment question there, and certainly for any other questions that you have, we'd really love to chat to you about them in more detail. Just after the webinar, you will receive that pop-up where you can complete the survey, and then you can also submit your details. And we'd love to speak to you further about how we can work with you and how we can give you guidance on your charity and any of the questions you have today. And then, of course, we can speak to you more about our membership and how that works. And so while this is a free webinar, we hope it's been really helpful for you today. We always appreciate your feedback, so please complete the 30-second survey at the end. Ushna and I have loved speaking to you about this today. We hope you found it beneficial, and we look forward to seeing you at the next webinar. So have a lovely day and a lovely end to your year.